Hello, everyone. Welcome to Dentons Privacy and Data Today. This is Season 6, Episode 4. As usual, I am Kirsten Thompson, a partner in the Toronto office, and I lead our National Privacy and Cybersecurity Group. And I'm joined by my co-host, Danielle Dudlzak, who is a Senior Associate in our Calgary office and has a very similar practice. Today, we seem to be focused all on Alberta. It's very Alberta-centric. In the news, we are going to discuss the breach of the electoral list and what exactly all that means. And we'll do a quick survey of some amendments coming mostly in public sector legislation, just to keep an eye on things and a scorecard of what's happening where. In the regulatory and legislative updates, the Federal Privacy Commissioner has issued some new age assurance guidelines, so we will talk about what that means. And we're going to discuss the OpenAI ChatGPT investigation because that investigation report was just released. And that has some important conclusions and recommendations in respect of harvesting data and use of data for training AI models. And then finally, in depth, we'll try and discuss a little more about that and what all of this means. We're also going to quickly touch on some jurisprudence around social media and the dead. Always a fun topic. So with that, Danielle, you are up first.
Perfect. Thanks, Kirsten. Lots going on in Alberta, as you mentioned, over the last couple of months. I'll kick us off not with the juicy topic of the breach, but just to briefly mention Alberta's Privacy Commissioner is warning that a new provincial law creates a concerning precedent by allowing a crown corporation to sell citizens' personal data. What is she referring to? Well, the Alberta legislature passed Bill 31, the Red Tape Reduction Statutes Amendment Act, which you might have seen, but it creates a limited exception allowing Alberta Gaming, Liquor and Cannabis, AGLC, to sell its online gambling platform, Play Alberta, along with the personal information of its registered customers to a private company. So as of late April, Play Alberta had more than 400,000 registered player accounts. Alberta's Protection of Privacy Act, POPA, which came into effect almost a year ago, actually prohibits public bodies from selling personal information for any purpose. So Bill 31 effectively creates a bit of a carve-out from that prohibition, allowing the sale if Cabinet is satisfied that there are reasonable measures in place to protect the personal information after it's been sold. So no doubt Play Alberta has lots of sensitive information, demographic data, geolocation records, behavioral records about gambling habits. And the timing is significant too, because on July 13th, Alberta will open its regulated online gambling market to private operators. So there's a core tension between enabling a potential commercial transaction, a sale of Play Alberta could earn the province a significant return, and upholding the privacy protections that POPA was specifically designed to guarantee. So the commissioner is concerned that this will undermine public trust in Alberta's privacy framework. The minister who introduced this bill says the AGLC would notify customers and allow them to opt out and delete their personal information before the sale. But what is notable and why I bring this up is that unlike PIPEDA, which contains a business transaction exception that provides a structured, conditional pathway for personal information to flow as part of the sale with safeguards and necessity requirements, the approach under Bill 31 appears to simply carve out a legislative override of POPA's absolute prohibition without imposing equivalent protective conditions, which seems to be the core of the Privacy Commissioner's concern about this precedent being set. So we'll have to look out for more detail in terms of what these reasonable measures would need to look like before any kind of sale, but I'm sure we'll be hearing lots more about this in future. So over to you, Kirsten.
Thank you. And still in Alberta, the real headline grabber has been the alleged breach, or the somehow it got into the wild list of it's called the electoral list. And so what essentially happened here is the list of electors was made public, and that is 2.9 million Albertans whose personal information was shared. So what is on the electoral list? Well, that's your legal name, address, postal codes, telephone number, unique identifier numbers, electoral divisions, and voting areas. That list of electors is obviously obtained pursuant to the Election Act and used for elections. It's the chief electoral officer in Alberta that's authorized by that act and is the one who's supposed to keep control of this. The electoral officer is then empowered by the statute to distribute this list to the usual people you would expect, and that is political parties, non-party affiliated members of the Alberta Legislative Assembly, and potential candidates in certain circumstances, with the obvious goal of making sure everybody can communicate with the electorate. And it governs the Election Act governs use and disclosure of the information. It doesn't really have the privacy protections that you would expect in privacy laws. So there's sort of two parallel regimes. So what happened here was the list was legally provided to a political party, the Pro-Independence Republican Party of Alberta. And then there seems to be a gap because somehow it was published online by the Centurion Project, which is a third-party advertiser in Alberta. No one seems to know how it got from the Republican Party to Centurion. And all sorts of mudslinging has ensued as a result. The Centurion Project then used this list to create a searchable online digital tool. People got upset, and the Privacy Commissioner got involved. Now, the problem the Privacy Commissioner has here is that it is not allowed to investigate political parties. It is a carve-out from the Alberta legislation. Contrast that with the current litigation in BC, where the BC Privacy Commissioner took the position that it was allowed to investigate the federal political parties' use of personal information. And then Pivota carves out federal political parties as well. So political parties, because they get to make the rules, sort of carve themselves out from these things. So the Privacy Commissioner was unhappy with this, but it has since launched an investigation, but it has launched an investigation into Centurion. Meanwhile, Elections Alberta went to get an injunction. That was granted on April 30th, and it sought to have Centurion take down the list. It also issued cease and desist letters to about the 500 Albertans who actually looked at the list and downloaded it. And then, so the OIPC launched its investigation on May 7th. And it's really looking at whether Centurion had the authority to collect, use, or disclose the information pursuant to Alberta's privacy law, whether it used reasonable security or had in place reasonable security arrangements to protect that information, and whether or not it had to comply with the duty to notify as set out in the breach provisions. Spoiler alert, I am going to take a wild guess here that is probably going to find that all of those were criteria were not met, just from foreshadowing. So we'll have to see how that unfolds. Expect to see more hand-wringing amongst the privacy commissioners generally about the governance, particularly privacy governance of political parties and affiliated entities. All right, so that's all the drama going on in Alberta. Now over to Danielle on the regulatory and legislative update.
Right, so you might have seen, but the OPC published new age assurance guidelines. They released two complementary sets of guidelines, one for websites and online services, and one for developers of age assurance systems. The OPC is accepting comments on both documents until August 4th, but together they represent the most detailed articulation of the OPC's expectations in this space. So I encourage you to read the article that we published on this topic. The link will be included in the email afterwards. But what are the takeaways? One of the things I hear frequently is, well, we don't target children on our website, so we don't have to worry about this, right? I think businesses often dismiss the idea that they collect children's personal information unless they're actually actively targeting this demographic. Targeting, however, is not what triggers obligations under this guidance. It appears to apply whether a website or online service actively invites children or children simply access it. So as a result, all operators of websites or online services should be able to establish that certain conditions are met to ensure that the website or service is actually safe for children. So the guidance goes through this and gives kind of a three-pronged test. So the website or online service is likely to be accessed only by a trivial number of children. So you're left to kind of figure out what trivial number means. Access is not likely to pose a potential harm to children. Or appropriate measures are taken to mitigate the potential harms to children. So it's clear from the guidance that businesses can't just block children altogether from accessing the websites just to avoid the issue altogether. So where a business intends to prevent access to age-gate content or service, it really needs to be able to demonstrate that there's a legal requirement to do so, or there is a potential harm specific to children that warrants this differentiating users by age. So organizations should really approach this guidance as an opportunity to reassess their data practices holistically, conduct a risk assessment, really understand high-level audience metrics based on the design, nature, and content of your sites, and maintain clear records of why you choose or choose not to implement age assurance. It'll be important to actually document and identify this risk and ensure that any approach that you decide to take is proportionate. So with the comment period open until August 4th is also the time now to engage with the OPC on any practical realities of compliance if you see those difficulties in your particular business. Age assurance, we've all heard, is a hot topic globally as well. The UK ICO and Ofcom issued age assurance guidance last month. That's similar to the OPC guidance. It's not directly applicable to Canada, but the principles are the same, and it does contain a lot of helpful examples and goes into a little bit more detail. So I would encourage you to take a look at this as well. We've also seen the OPC has published the results of their most recent privacy sweep, highlighting how child-friendly practices on websites and apps can protect children's privacy online. So that sweep, you might recall, was a coordinated effort between 26 data protection and privacy authorities around the world. Generally found more privacy protections in place than the last sweep conducted in 2015. Positive steps, but there's lots of room for improvement. So we'll send the links around after so that you can check this out. Sticking to the theme of children's privacy, we saw in late April, the US Senate Judiciary Committee unanimously advanced the guidelines for User Age Verification and Responsible Dialogue Act, the GUARD Act, they're calling it, marking a significant development in federal efforts to regulate certain uses of AI involving minors, which is quite significant because in the US so far, we've seen quite a patchwork of things going on. So this is a federal effort specifically focused on regulating AI chatbots that are publicly available to consumers, with particular attention to the risks associated with use by minors under the age of 18. We've actually also seen in Manitoba in late April that it plans to ban youth from using AI chatbots and social media. So as of May 13th, its premier indicated that Manitoba is looking at appointing a commissioner or regulator to enforce the proposed ban on social media and AI chatbots for children under 16. It was acknowledged that there's a lot of details still to be worked out, so it probably is going to be some time before measures could potentially be in place. But some details that have come to light since this announcement in mid-May, the ban would apply to those aged 16 and under. Seems like children and parents aren't going to be penalized. The enforcement effort is presumably directed entirely at tech platforms. And they expect the first phase to be a ban to be rolled out in schools. So we'll have to watch this space. This is certainly becoming a much more prevalent trend. Over to you, Kirsten.
All very interesting. Okay, turning now to the joint investigation of the various privacy commissioners on OpenAI. And this was an investigation into OpenAI, the company behind ChatGPT. Most of you will be familiar with it as just ChatGPT, but it is actually the entity behind it. So this investigation was commenced in April 2023, and while joint investigations are common, this one's a bit unusual in that Quebec CAI, which is their privacy regulator in Quebec, joined in. It doesn't always participate in the joint investigations. So what they considered was OpenAI's compliance with PIPEDA and the provincial counterparts in BC, Alberta, and Quebec, and this was in relation to OpenAI's collection, use, and disclosure of personal information for the purposes of developing, training, and deploying ChatGPT. Again, we'll cut right to the end and I'll save you reading 37 pages. The offices found that ChatGPT, OpenAI, contravened the acts for a number of different reasons. In particularly the ChatGPT, the over-collected information, so it wasn't discriminating when it scraped everything off the web. There was a lack of valid consent and or transparency, and I'll explain why those two things go hand in hand. Factual inaccuracies, so the information that it did use to train wasn't always accurate, and therefore the personal information did not meet the accuracy requirement. And there were issues related to an individual's ability to access, correct, and delete their personal information. In other words, the rights under the privacy laws. And finally, a lack of accountability within the organization. So they didn't know who was in charge and who was responsible and who to contact. Now, many of these issues were subsequently addressed by OpenAI as it developed its subsequent ChatGPT models. I really want to focus on a couple of things which have fairly significant implications for not only organizations' control of information, but its use of their use of information for training AI. And the privacy commissioners struggled with this. This is perhaps one of the most convoluted and complex reports of findings that the privacy commissioners have issued, in part because it was a joint investigation amongst 4 different entities, all at federal and provincial levels, all trying to look at different, similar but different laws. But they all struggled with this, the idea that these companies and their technologies had to be given some leeway to use this information, while at the same time having to draw a line somewhere to say, you can't use it this way. And the privacy laws are generally inadequate because they're so outdated. So what did they find? Well, Privacy Commissioner federally, OPC, sort of got backed into a corner here, and it did say clearly that the development, implementation, advancement, operation, and deployment of AI systems can be appropriate purposes for processing personal information. So, yes, you can use personal information for the purposes of training AI. Not surprisingly, there's a big however tacked onto that. However, processing of personal information for such purposes must be necessary, effective, and proportional. This should not be a surprise. This is the common test. How do you assess that test? Well, you have to take into account the sensitivity of the personal information, the legitimate needs of the organization, and the risk to individuals. What does that mean in plain English? Sensitive information that's hanging out there on the web, it does not give you carte blanche to use it to train in a harmful, that might cause harm to an individual. That's a paraphrasing. There's a metric you'll have to do and a grid that you can draw when you're assessing your own situation, but that's really the gist of it. So what does that mean? If you are proposing to do this, train AI, you need to take into account, so you can take certain steps to minimize the privacy impacts. For instance, avoid overbroad collection, avoid the use of personal information, mask personal information where you can, so it's not included in the model outputs. Use certain technological and other measures to prevent unauthorized, inappropriate, or potentially harmful use of the AI system. And so by adjusting these factors, you can often get to a place where you can meet that test of necessary, effective, and proportionate. The other interesting takeaway from this report of finding is the idea of consent. OpenAI made a good point, and that is, look, we're running around getting this information, we're training it. Even if you allow us to do this, you guys all require us to get consent. There's no way we can get consent from end users. Like, we're just running around the internet scooping up information. This isn't reasonable. And the privacy commissioners did struggle with this, and they it's like a Supreme Court decision. They all went in different directions on this. So federally, and this is pretty consistent, the privacy commissioner said consent is required to process personal information contained in publicly accessible websites and licensed third-party sources. So the first one, we should know. Just because it's out there on the internet doesn't mean you can use it. Publicly available is defined in PIPEDA, and there's a set of regulations that says this stuff is publicly available for the purposes of PIPEDA. Everything else isn't. Clearview AI previously got in trouble for doing something very similar. Interestingly, it's modified its approach here. It says you need consent for the processing of personal information contained in publicly accessible websites and licensed third-party sources. And this was a jab at the data brokers. So just because you're buying it from a data broker does not get you out of jail in terms of consent, neither does harvesting it from the internet. It says the privacy commissioner said organizations cannot rely on implied consent, because remember, you can need consent. You can get express consent or implied consent. And OpenAI had argued that, well, they put it on the internet, and Clearview AI tried this. They put it on the internet. They impliedly consented to everybody's use of it. Privacy commissioner came back, said, yeah, no, that's not the case. You have to look at the sensitivity of the information and the reasonable expectations of the individual. When someone put something on their social media, they did not reasonably expect someone else to come along, harvest it to train an AI system. And some of the information that you were using was sensitive, and so you don't meet this appropriate, the necessary, effective, and proportionate tests. Now, organizations can rely on a third party to obtain required consents, either express or otherwise. But that, if you're going to do that and you rely on a third party, you have to make reasonable efforts to ensure the third parties actually obtained personal information in a lawful manner. So just because you don't do the scraping and the other guy you hired does, that's still on you. So you can't just farm it out and turn a blind eye to whether or not it's lawful. You have to give appropriate notices, and again, you have to retain the required consent. How do you prove that? Privacy commissioners suggest not only do you have a contract in place that requires a vendor to do that, but you also actually have to take steps to monitor that third party. The other piece here is that Privacy Commissioner found that public transparency measures can be sufficient to support implied consent. So let's say you're not using sensitive personal information and you're just using the basic stuff. If you are telling people what you're doing and people are familiar with the technology, then you might be able to use implied consent. In other words, OpenAI would have been able to train on non-sensitive personal information if it had been people had generally been aware of it. And this is a bit of a shifting sands argument. The privacy commissioner here says, people are familiar, as the public becomes familiar with technologies, it's more likely you'll be able to imply consent because people reasonably expect that these technologies are going to use things. Then it says in novel technologies that people aren't familiar with, you're not going to be able to make that assumption. So if you're like cutting edge doing stuff like that, you're probably going to have to take more steps to educate people. You might have to have pop-ups. You might have to be more explicit in order to ground implied consent. So that was what the federal privacy commissioner concluded. The CHI was not quite convinced. In Quebec, it says, yeah, this all generally hangs together, but we reserve the right to analyze this on a case-by-case basis. So get back to us. Oh, by the way, in Quebec, there's a default provision that you have to set your privacy settings to the highest level. So it really has to all be opt-in. And that applies to both collection, use, and disclosure. It's not just one and done. Alberta and BC went entirely the different direction, and they said, yeah, we looked, very good privacy commissioner, federal privacy commissioner. However, we have different legislation, and the problem is our legislation says you can't do this. And they found that OpenAI cannot obtain consent in accordance with the requirements of the current legislation in those provinces. So what does that mean? OpenAI is going to have some challenges here. It's going to have some impact on the privacy modernization. BC and Alberta's private sector privacy laws are up for review. BC said very clearly it's thinking about including a legitimate interest privacy exception. PIPEDA, the federal privacy commissioner, really tied itself in knots trying to accommodate the protect privacy but allow technology to thrive. So I expect we'll see some legitimate interest type provisions in any new PIPEDA whenever we get it. Okay, that was a long-winded explanation, but keep an eye on this space because this is an interesting development as the privacy commissioners grapple with AI. Danielle, back to Alberta.
Right, taking you back to Alberta, really briefly, just a look at the public sector. The OIPC of Alberta issued new resources to assist public bodies in complying with their requirements to establish and implement a privacy management program under Alberta's POPA. So this requirement becomes mandatory next month following a one-year transition period. And the guidance identifies 7 core requirements of what a privacy management program should look like. I won't go through them, but it does mirror the building blocks of privacy management programs that we see from guidance by the OPC and the Alberta and BC OIPC as well. The guidance is going to help public bodies understand how best to develop a privacy management program and what the OIPC is going to be looking for when assessing this. Might be useful to review if you're a service provider to a public body, as a companion document will give you some information as to what your contracting terms will look like. And companies that can't demonstrate equivalent practices, they're going to face challenges in procurement and partnership context. So it's worth taking a look at that if you are in the private sector, but work in the public sector as well. Just to keep an eye on and be aware of other public sector privacy law changes. This will also impact you if you're doing business in the public sector. In BC, there's amendments proposed to the Freedom of Information and Protection of Privacy Act. Proposes to amend the current BC FIPA to govern how public sector entities collect, use, and disclose personal information. So we see things notably like modified response timelines, broadens the ground for allowing public bodies to dismiss requests and gives bodies the ability to proactively release certain records without forcing the public to go through a formal freedom of information process. Also in Ontario, we see Bill 97, which will introduce significant amendments to Ontario's Freedom of Information and Privacy Framework under both FIPA and the Municipal Freedom of Information and Protection of Privacy Act, a mouthful. But the reforms are going to modernize the Freedom of Information and Privacy Framework by strengthening confidentiality for senior government offices, thereby weakening disclosure obligations, which has been heavily criticized by the media and by the Ontario OIPC. But on the bright side, the freedom of information processes look to be streamlined, and they also introduce stronger cybersecurity obligations across the public sector. Turning really briefly to the Federal Privacy Act, there will be a review and modernization of the Federal Privacy Act, an act that was launched over 40 years ago with no major updates to speak of, so room for improvement. But there's a focus on expanding data sharing across government programs, enhancing transparency, and increasing the powers of the Privacy Commissioner. So the government is collecting public feedback on the proposed policy approaches until July 10th, and then we'll have to wait and see what comes out of that. So speaking of international standards, I'll turn to Kirsten quickly again for some interesting developments in the UK that actually also has application in Canada as well.
And this is something that we've seen in our own privacy practice and in helping clients respond. So we have seen a significant uptick in AI-generated access requests, both on the private sector under PIPEDA and particularly in the public sector. AI is a great tool. Unfortunately, it's not really good at drafting these things. So I suspect the various regulatory authorities are also seeing an uptick in these, and as organizations are struggling to respond to them, particularly within the timelines, the privacy commissioners are weighing in. And so we see the UK ICO, which is their privacy commissioner, just issued guidance. In this case, it was for public bodies around AI-generated access requests. Our privacy commissioners have not yet issued anything, but you may want to take a look at this because it roughly parallels our regime. They note that there's been an uptick, that these things are very poorly drafted. They tend to be longer, broader, and less focused. What does that mean for organizations? You still have to respond. You cannot ignore an access request just because it's AI generated. They put together some guidance around that. So AI generated, can't just ignore it because it is, but you do have an obligation under statutory requirement to actually make inquiries. So if you don't understand it, it's too long, it's too broad, go back to the requester and ask what they're looking for. Seek clarification. They do say there are tools within that statute, and there are also tools within the Canadian statutes. You can apply cost requirements and fees. They have to be basic, but that can sometimes deter things or at least encourage requesters to ask for less information in the public context. In some cases, organizations are permitted to refuse requests which are overbroad or vexatious. Unfortunately, not all Canadian legislation contains that. For instance, Ontario includes it. Alberta just amended its public sector privacy law to include that. PIPEDA contains nothing, so you can get a million requests and you're obliged to respond to all of them. So keep an eye on this. It is becoming an increasing problem. Maybe develop a strategy on how best to respond. Thank you for attending. Our next webinar will be mid-June, and then we will go on hiatus for the summer while you enjoy your cottages and cabins respectively, or lakefronts or ocean fronts. And we'll see you next month and then again in September. Thanks, everyone.